Can you repeat that?
Sure. I'm letting you know your rights. That's not something that's going to, I can't tell you that's something that's not going to happen. That's not something that we're asking for the court to do. But that's something that's a right that I have to read to you.
All right.
All right?
Yes. Sorry.
So I'm reading your rights now. I'm going back to reading your rights that you're giving up by entering into a plea. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, that you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? And after each right, I'm going to ask you to say yes or no if you understand, okay? You understand that you're giving up the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183-572, where you're charged with one count of conspiracy to violate the Racketeer Influence and Corrupt Organization Act, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for the felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And Your Honor, if this case were to go to trial, the state would expect to prove that the organization YSL is an enterprise, that this defendant is a part of that enterprise along with his other co-defendants, and together on or between the 24th day of January 2013 and the 8th day of May 2022, they did unlawfully conspire to acquire, maintain, directly and indirectly, an interest in and control of United States currency and other personal property through a pattern of racketeering activity, and also while associated with an enterprise, did unlawfully conspire to conduct and participate in, directly and indirectly, such enterprise through a pattern of racketeering activity. That the associates of the enterprise Young Slime Life, also known as YSL, that they did conspire to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. And in furtherance of the conspiracy, the defendants engaged in certain activities which are enumerated. Some of those activities include preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating an allegiance to the enterprise and a willingness to engage in violence on its behalf, that maintaining armed individuals ready and willing to preserve, protect, enhance the reputation, power, and territory of the enterprise through the use of violence, and obtaining money, weapons, and other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. The state will also prove that YSL is a criminal street gang that started in the late 2012 in the Cleveland Avenue area of Atlanta, Georgia, that some of the founders were Jeffrey Williams, also known as Young Thug, also known as Slime, Walter Murphy, also known as DK, and this defendant, Trontavious Stevens, also known as Tick, and also known as Slug. That YSL uses a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. And we would show that this defendant had a tacit understanding of the enterprise and furthered the enterprise's goals with several acts. Some of those acts are from January of 2013. This defendant, in which he pled guilty, was accused of aggravated assault, in which on that day, an officer with the APD Police Department was working in an undercover capacity. That
Actual acknowledgements are as follows. Number one, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 10, defendant has personal knowledge that on January 10, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. Number 11, defendant did not murder Donovan Thomas Jr. and was not a party to the crime. Number 12, defendant did not murder Shamel Drinks and was not a party to the crime. Number 13, defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of the murder, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E.
On most vacations,
Same protocols as everyone else.
During the course of the pendency of and prior to the indictment of the case that you've been called to testify for today, have you scanned casings into the NIBIN system for the Atlanta Police Department?
Yes.
And would you please tell the court how it is that you ensure the accuracy of the results that you gain as a result of those scans?
When we scan those in there, we have to review them when we do the correlations. We also have a secondary person review those correlations also to see if there's any errors that were made. And then if any potential leads are found, a third person will look at those to see if there's any type of mistake.
And have you done that with each piece of evidence that you have placed onto the NIBIN system?
Yes.
Would I, an ordinary layperson, be equipped to walk into the Atlanta Police Department crime lab, even if I'm escorted with someone, and place a shell casing into NIBIN?
No, you would not. You have to have access to the computer, and you have to be trained first.
If you gave me access to the computer and I went up to the system with a piece of evidence in the form of a shell casing and placed it into the system, with you standing there next to me, would I, an ordinary layperson, without your training, background, and experience, be equipped to understand any outputs or results?
You would not.
Explain to the court what it is exactly that happens when you take a piece of evidence and input it into the NIBIN system.
We put the evidence in. It takes upwards of 7 to 7.5 minutes for it to take all the pictures of the cartridge case. Again, it's high definition 3D imaging. Once it does that, it assigns that cartridge case a numerical value, done so by a complex algorithm. Once you submit it, it then takes and searches that value against any other cartridge cases in the system to see if there's any similarities close enough to call it a potential lead.
And this high definition 3D imaging, is it in the form of, or conducted, or captured by any kind of particular microscopic camera, or is it just a regular?
It's a microscopic camera at 40 power magnification.
How many?
40 power magnification.
And when you say submit, it then submits.
Yes.
What do you mean?
It downloads to the data concentrator where all of the other cartridge cases are stored for it to search.
And what is it that your training allows you or causes you to do that I wouldn't be able to do if I went up and just put a shell casing into the system?
You wouldn't be able to open the system up without having an access code password to be able to get into the system, and then you would need to learn or know how to create the case.
How to do what?
Create the case, which is putting all the parameters in, the case numbers, the caliber, the firing pin impression shape. You would have to know how to do all that to be able to open the system up to insert the cartridge case.
And is it the experience and training that you have recited to the court that affords you the knowledge that you have regarding those parameters, the firing pin impression shape, the caliber of the ammunition, which allows you to then enter or input that evidence into that system?
Yes.
Is that information that is known to the general public?
Not generally.
And I should say, absent specialized training that you described for the court here.
Correct.
Just one second. Your Honor, the state tenders Jennings Kilgore as an expert in NIBIN technology.
All right, does anybody want to voir dire Mr. Kilgore?
Judge, I'm sorry. I'm going to need a little bit of clarification if I can. He's being tended as an expert in NIBIN technology. I'm not quite sure I know what that means. Is he just the expert in explaining what the system does? I don't know. What does that mean?
Your Honor, Mr. Kilgore has testified as to his training and experience that allows him to speak specifically about the results from NIBIN, I don't want to use the word examination because there is a separate person that does the firearms examinations. But the results of the input into the NIBIN system of leads that are generated and evidence that is input into NIBIN. This is a technology that is background and training specific. The ordinary person on the street wouldn't be able to speak intelligently about what a NIBIN lead is, what it does, what it means. So yes, NIBIN technology.
But I haven't heard him testify about results that come out of the NIBIN or if there are any charts, if there are any conclusory, any reports. I haven't heard anything about that. Essentially, it seems as though he's being tended as a witness who can say that this is how the machine works, or this is how you input the information into the machine. It might be a little bit more technical than that, but it doesn't sound as though this is something that requires expert testimony.
Well, the word you just said, technical, Mr. Adams, is the reason why it's a subject matter that would be that the average person wouldn't
Technical
know.
meaning it's a machine. I mean, I can put something into a Canon copier, but I can't tell you how the Canon copier works or explain anything that comes out of it. So it sounds as though he's being tended.
Would you like to lodge an objection?
No, I guess I'd like to voir dire him.
Okay.
Your Honor, prior to Mr. Adams having that opportunity, as I'm happy to yield the floor to him to do, I'd also, in addition to NIBIN technology, tender Jennings Kilgore as an expert in the utilization of the NIBIN system itself.
Case analysis.
I do not recall if it was T-Mobile or Sprint.
All right.
There were several records that we obtained from Matt's case. One was definitely T-Mobile, but again, Mr. Fleetwood's, I don't recall.
All right.
I can refer to my report, I can tell you, but
Do you have your report anywhere in front of you?
I do not.
All right. That's all right. That's all I've got. Thank you.
Okay. Anybody else? Mr. Jimenez, go ahead, sir.
Good morning, Your Honor. Good morning, State.
Good morning, sir.
Sudi Chalak, Jimenez, on behalf of Mr. Dorsey. How are you, sir? Good morning.
Good, how are you?
Good. All right. I want to just have a few questions now. You say you received this data from the cell phone carriers, is that right?
Correct.
And this data was created, this is kind of like, it's a data dump, it's just metadata they give you everything, is that correct?
I wouldn't say everything, but, the date and time of the call, who the called party was, how long the call lasted, again, the cell site, the sector of the cell site. So, yes.
And when you say cell site, the reality is that there are millions of cell towers throughout the United States, is that right?
There are quite a few.
And the phone company doesn't own any particular cell tower, is that right?
Own? I mean, they may contract out for property, but maybe I'm not understanding.
Let me rephrase. One cell tower could actually share and be used by multiple.
Absolutely.
Yeah. And then so whoever controls that data then gives it to the cell tower, again, then gives it to the phone companies, is that right?
Well, no, the phone companies will they have a retention in place where they also service the antennas that are attached to these cell sites. So, I mean, this is just records. I don't know the intricacies when it comes to who gives who the records inside that company. I don't know how to answer that.
But you said during direct that whatever records they do have, they collect them for their own.
Cash App giveaway. I don't care if the video's on pause. I don't. Cash App giveaway. Like I said, bro. You feel me? All you gotta do is hit that like button, bro. Once you hit the like button, bro, all you gotta do is comment your cash tag, bro. It's not that hard. Feel me? I see a lot of y'all hitting the like button, but y'all not.
Use.
Right.
For example, they collect it for billings purposes.
Right.
Also,
I'm not object to that line of questioning. I don't think he can testify why phone companies collect records. He's not a phone company expert.
I think he just answered it. He does know. If he knows, he can answer it. If he doesn't know, he can say, I don't know.
I got you, Mariah.
Can you answer that, Mr. Worrell?
The records initially, when I would say there are many factors when it comes to why the records were kept kept.
The fact that our
A motorist makes a desperate getaway attempt by leading Coweta deputies on a foot chase down a busy interstate. Fox 5's Doug Evans has more on what led to this literal run from the law.
Sit back here, I'll explain it to you, okay?
Coweta County deputies say they pulled over Christopher Close for driving 90 miles an hour in a 70-mile-an-hour zone on Interstate 85. They've just learned that he's wanted in Lowndes County for counterfeiting. They're about to let him know that they know he's wanted. And deputies say this is always a dangerous moment in a traffic stop, and this one is no exception.
Let me just turn around real quick, okay? You gonna get tased?
The deputies' tasers have no effect, and the video shows that Close then makes a desperate move to cross the interstate. Here's what happens next. Deputies say Close had tried to jump the median wall but fell back. He was taken into custody.